So, hello, welcome. Happy Friday. Or should I say Friday? I like Friday. Not as much as I like Thursday, and I don't know why that is. That's just where I get my jam at. Thursday's like, all right, I got Friday left to go. I got Saturday and Sunday. But here we are. It's Friday. Starting teaching this coming week, which is exciting. I teach business law at Southwestern Community College, which I really enjoy. There are a lot of things to love about teaching that I didn't know that I would love about teaching until I actually taught. I've taught in the past, but, like single classes or single, things. Taught at church, things of that nature. So it's fun. I've been doing this a couple of years now. Sometime, probably not today's episode, but sometime I would love to talk to you about when I taught in prison and what that was like. They let me out, which was good. But anyway, I got to meet some very, very special people when I taught in prison, and people that, although obviously had made some not great choices in their life, I'm a big believer that we are not the culmination of our worst decisions. Okay. So, which is one of the reasons why I am an attorney and why I believe everyone has a right to representation regardless of what they've done. Because I believe that that we all make mistakes, that we're all imperfect, and that to be merciful to each other. And I'm not excusing their crimes. Okay, don't misunderstand that. I'm simply saying that everybody deserves respect and mercy regardless of what they've done. And I get it's painful. It's hard to do. It's something that we struggle with as a society, that when somebody does us wrong, how we react to them. There's so many ways that it happens. And I bring that up because I recently have dealt with this in a business and personal sense. Someone wronged me, and I didn't react the best. I'm human. I could have reacted better. And in business and in life, the slower you take it in when reacting, the happier you'll be. You'll react a lot better than if you are shooting from the hip. Okay. So today, we're going to be talking about common defenses to breach of contract. This is a topic that I deal with almost constantly, because one party will sue another party for breach of contract, and depending on where I'm at, I'm either suing or I'm being sued. Not me personally, the client. And so I have to mount a vigorous defense if they're suing my client. Okay. So these defenses are not all-inclusive. There are other things that have to be thought about and different strategies that you can use. But overall, these are them. And these will help you when you're drafting contracts, when you're negotiating contracts. If you don't have an attorney, which by now I would like to hope that you have an attorney, I would like to think that you would learn something from these videos. And one of them is that an attorney is worth their weight in gold. So with that in mind, happy Friday, and let's get started, shall we? All right. So number one is there is what's called the Statute of Frauds. And there are certain contracts that have to be in writing. If a contract is verbal, that must be in writing. then that's one of the defenses that you can raise. That is, that agreement was supposed to be or required to be in writing. Now, the simple answer is it depends on the contract. Anything involving the sale of goods over $500, services that are to be performed beyond a year, or, of course, I forgot to do that. Anything involving real property, so think landlord, tenant, real estate, that type of thing. Think anything involving land must be in writing. Okay, so that's something to consider while you're making decisions about contracts. But if handshake deals happen, but one, I don't recommend them, and two, honestly, it's better if you don't, and you get everything in writing. Honestly, it's a better way to go. It's a smarter, stronger argument. That way there's no confusion about the writing. And so the idea being that if you can get it in writing, get it in writing. Very simple. Don't do a verbal agreement. Don't do a handshake deal. Okay. Next thing is if the contract is indefinite, if there's a lack of time or specifications as to how the job is to be performed, what is to be performed, if there's ambiguity in the contract, then how is there what's called a meeting of the minds? And that's what this is a defense. There was no meeting of the minds because the terms were indefinite. It's not enforceable because, well, how could I be expected to follow the agreement if the other party wasn't clear on what its expectations were? I ran into this with the case that I worked on a while back. The other part, the person that drafted the contract thought vagueness was their friend. Newsflash, it wasn't. And so they intentionally left things out that they should have put in. And so the vagueness is typically construed against the drafter. So if a contract is so indefinite, then it can't be enforced. Okay. And so, like, for instance, agreements to agree or letters of intent or things that are just kind of a feeling or a something just is starting, that's not considered a contract and is typically not enforceable. Another defense is that there's a mutual mistake. Okay. The courts aren't going to hold it against the party that didn't make the mistake, but in order for a contract to be defended against a breach of, then there needs to be a mutual mistake. Both parties had some sort of misunderstanding about the contract. If it was one party that misunderstood about the contract and not the other party, then that's where it gets a little tricky. It's usually construed against the person that makes the mistake, not the person that is the, in other words, who does it hurt? That's how that's construed. The next thing is if you are lacking capacity. This applies if you are mentally incapable of drafting a contract or not drafting, of signing a contract, not drafting. Or if, for instance, you're a minor, you don't have the legal capacity to contract as a minor. Under the age of 18 is the typical United States minor. There are exceptions throughout the world. I'm not suggesting that this is complete, but the idea being that now there are some exceptions to this, but we're not going to talk about those. This is a defense. So if you signed a contract when you're under the age of 18, it's possible to get out of that contract because of your age. Okay. So that's why it's so very important. The next thing, and this one is a little more nuanced, is if there's fraud. So someone misrepresents the terms of a contract, you can, that's considered something you can get out of, defense for breach. So you don't have to comply if someone induced you to commit, not induced you to commit fraud, but was committing fraud upon you. There's a difference between those two. Which fraud is defined as a material misrepresentation. So say there was, Here we go. Oceanfront property in Arizona. That's a good one. There's no such thing, and if someone tries to sell you oceanfront property in Arizona, that's considered fraud because it doesn't exist. Same thing goes with if someone draws up a deed to a property they don't own or a property that doesn't exist and they sell it. There was a meme recently where a guy was selling property on the moon. Well, A, he doesn't own that property, and B, it doesn't exist. You can't build on the moon. It's just not possible. So that would be fraud. You're not expected. If he demanded money for that, peace out. You're done. That's it. There's no way the courts are going to enforce that contract. Another one is duress. Okay. If you sign an agreement under duress, typically economic duress, you can be let out of that agreement. Now, duress being, and this is a very simple explanation, if someone puts a pen in your hand and says sign this or else, right? You see this on the movies all the time. I love it because I sit there and I go, are you kidding? That contract is so easy to get out of. Like, a piece of cake. Like, that would be so easy. But you see someone put the pen in their hand and say sign or else, right? I'm going to kill your cat, or I'm going to squeal on you to the government, or I don't know, whatever, something stupid, right? You see this in the movies. But in real life, if someone coerces you to sign an agreement and it's duress, and that you don't really have a choice because of that, then you're not expected to take that contract or to honor that contract. The other one is undue influence. Now, this one's a little bit harder to explain in the sense that most of the time, most contracts are going to be acceptable as long as both parties agree to things. But imagine if you're dealing with Warren Buffett or Elon Musk or Bill Gates or Steve Jobs or any of these types of people, and they basically ram contract terms down your throat. There could be undue influence. Or say an attorney puts something in front of you and says, you have to sign this or else. Okay. Because of the imbalance of power, that's what we're talking about here. Imbalance of power and unavailable options otherwise. So a contract of adhesion, and that's another type of contract that we're not going to talk about, but a contract that is so one-sided that it's completely unfair. Okay. So that's undue influence. It is the power differential between the two parties. Simple enough. Next one is an unconscionable contract. Now, unconscionable, it has to be something that is grossly unfair. Not just, I didn't really like the terms. These are hard to deal with in court. I'm not going to lie, because of the way the courts look at people trying to get out of a contract. Generally speaking, they hold them to the contract. Okay. But I'm saying these are possibilities. So these are defenses that I would raise if I'm defending a client against a breach of contract. And that's where that comes from. So unconscionable, grossly unfair. Like, it's significantly unfair. Essentially, one party is taking advantage of another party. That's the unfair factor through the contract. So see, these are nuanced differences. These are some of these apply and some of these don't. It only matters in law, right? Most people would be like, well, that sounds like the same thing. It's not, and in law, it's not the same thing. But people, we've gone through cases that have dealt with different elements of these, and so that's why it's important to distinguish these differences. Now, undue or unconscionable is the contract itself, right? Undue influence is the party's power balance. Unconscionable is the grossly unfair. So maybe there's no power differential, maybe they're on fair grounds, but the contract itself is grossly unfair. Again, hard to do, but you got to raise it. You got to have a defense there, because if you don't raise it, it can't be done. Estoppel, when one party relies on a statement by the other party to their detriment. And the typical most common is a promissory estoppel, which means a contract is formed based on behavior. And someone says, I will give you $1,000 for each college course that you complete. Well, you don't have any plans of going to college, and it's a unilateral contract at that point because you're not giving up anything. Remember, a contract requires consideration and meeting of the minds, offer, acceptance, consideration. But in promissory estoppel, I'll give you $1,000 for each college class. Now, this is just pretend. Do not watch this video and expect I'm going to be promising anything. That just doesn't happen or exist. But so let's hold on 1 second. Let's go to this one. The point I'm trying to make is that if you promise something and I then enroll in college, which I had no plans to do, and I then each college course, I take 5 college courses. That was the promise. You promised me that you would do that. Okay. That you would pay me for each college course that I took. You were vague as to the terms. Again, you want to do, or you say $1,000 for each A you get. You take 5 college courses, you get 5 A's. Okay. You can use that promise because you wouldn't have done that had you have not received that thing, that offer, had they not offered that $1,000. So through their actions, you can, through your actions, you can bind that other party. Courts don't enforce gifts. It's not the same thing. So if there's no action required on your part, if they say, oh, I'll just give you $1,000 per, not even per anything, I'll just give you $1,000. You can't then turn around and sue for that $1,000 because it would be considered a gift. Gifts are not the same thing. It doesn't create a contractual relationship. That's just is what it is. All right. So the last but certainly not least part of this is, oh my gosh, why did it do that? I swear. Never a dull moment around here. The next thing is an illegal contract is unenforceable or voidable. The most common example, and this is one I've talked about before, is if someone is renting a dwelling in their home that's not permitted, it is an illegal dwelling. Okay. And because it's an illegal dwelling, that contract is unenforceable and voidable. And you can actually sue to get your money back for any money that you've spent in that. So, for instance, someone rents out their garage. They don't get the permits to it. They don't do what they're supposed to do. They just kind of do their thing and think they can get money for it. Okay. You have every right to turn your home into however you want it to be. There's no law that says that you can't. There's zoning restrictions, and I'm not going to get into that, but you could turn your garage into a living space. That's not the issue. It's that it has to be a permitted living space in order for you to charge rent for it, because it requires certain things that exist for that to be a livable space. Okay. So that contract would not be enforceable because of those reasons. Now, that being said, if you don't know that, then you probably wouldn't know to try to get your money back. But that's how it is. So, well, that's it. Those are the most common. There are other defenses to formation, and certainly if I was defending you in a breach of contract lawsuit, I would raise those in the answer. But these are the most common, the easiest to understand, and certainly the ones that would make the most sense most of the time. So these are the ways that it isn't about getting out of a contract that you don't like. That's not what this is. This is about not being held to a contract that are defective contracts for whatever reason, right? That's what these have to do. So it's about balancing back that power. Most of these are imbalances of power between the parties or between the terms, the contract, that type of thing. But that's where we are. That's what it is. So if you have any comments or questions, make sure to leave them below. I'm here to answer them. We go live every Monday through Friday, except for holidays. So please join me. I look forward to hearing from you, and have a great weekend. We'll talk to you soon. Bye.